Sometimes you want to yell at the screen, which happens with, mock juries too, and get them back on track. But, juries as a whole do a really good job. You see that people really do want to do their duty. It's rare to have somebody in there who, is really not trying to do their best job. And they often arrive at a logical conclusion, but the way they get there is sometimes a little serpentine. And so, you learn that their their decision making doesn't always follow the way that you think, when you're portraying the case and you think you set out, A, B, and C, and this is how the jurors are going to follow the path. They don't, because they're not attorneys and they're not thinking about it the same way that you are. And you hear a lot of discussion about their own experiences and past things that have happened to them and how that relates to the case. And you see how all of that unconscious part of that forms their decision making process. Yeah, I mean, it always depends on the facts, and every case is different, even though you might think that, they're very similar. Every plaintiff is different, and that matters too, how likable your client is and the specific facts of the case. But, some of the things that help are even just the words that you use. I hear all the time attorneys use the word accident.
Ooh,
An accident to people is something that happens without anybody at fault. Accidents happen every day. You spill your milk on the counter, that's an accident. If you have kids, they're always saying, "It was an accident, mom. I didn't mean to. It was an accident." And so, moving from that to a wreck or a collision, you don't want to say wreck if it's really smaller speeds. But even collision, something like that that portrays that somebody had a part in it.
yeah.
You never want to say a low speed collision or a low speed accident. You want to portray it as not a lot of visible property damage, because we all know you can't judge a book by its cover. And so you can talk to jurors about that in voir dire. And, sometimes when there's not a lot of damage to the vehicle, that means that all that force went straight over to your plaintiff, right?
Yeah.
So I think even just being careful with the words that we use can make a big difference in those types of cases. When people hear a fact, they don't just hear the fact in isolation. In everyday life, even not even in court cases, when you're just living your everyday life, you hear a fact and it gets brought into your brain and filtered through all of your life experiences as to how you feel about that fact or what you even remember about it or how you remember it. And so often you'll see jurors deliberating and they all heard the same facts and they have completely different memories of what the facts are or how they, put all the pieces together. And that's because of their life experiences. So, unconsciously the jurors are filtering all that information as it comes in. And if the story that you're trying to tell fits with something that they can get on board with based on their beliefs and is consistent with that, then they will accept in that fact and fit it into that framework. But if it's something that goes against their current beliefs, they will either change the fact in their minds and remember it a different way that makes it consistent, or they will throw it out and forget about it altogether and focus on the things that do fit into that framework. So you have to come up with a story that resonates with jurors based on what their attitudes and beliefs are. And what you have to realize about that too is each fact that comes in, the earlier facts are important because it sets up what that framework is for them. And so if you aren't winning out of the gate, if you, sort of mess up on your voir dire and your opening and think, oh, well, I'll catch up later. It doesn't work that way because the facts that come in are already filtered by the previous facts. So if they're starting to be on your side in voir dire and opening, then facts that come in that are against you, they'll start to throw them out and or alter them. But if they're already leaning against you, then the facts that are good for you, they're going to do that too. And so you have to be really careful to set yourself up right from the beginning because it's really hard to turn it around when you get further into the case. There's a balance between asking useful questions. I hate when attorneys, they go in there and they just want to ask leading questions that the jurors can see through it, right? They know that you are trying to push your propaganda onto them as a trial attorney. And so you can't do that because you lose your credibility with them very early on. And it's not doing you any good because you're trying to push your case in a way that they're going to, disbelieve it anyway because they don't like the way you're doing it. So, you have to set up for the bad facts, but ask it in a way that, says that there's more coming, So if you heard this really bad fact about my client, how many of you feel like, regardless of what the rest of the evidence, facts, or the law say, that, case is closed, we should just go home? And so you're setting them up to think, okay, well, I guess he's hinting at the fact that there's more information that applies to this than what they're asking me about right now. And you can set up themes. So, you can ask people, if it's a rules type of case, then you can ask them in voir dire about, what rules do you follow in your home or in your work and why do you have those? And so, hinting at it in useful ways, I think is okay. And otherwise, I think you do have to sort of expect that jurors are going to wait. They will wait for your opening for most of your facts. You just have to set them up for the fact that everything you're talking about in voir dire is out of context, that there's things that are going to be put in context once they get the facts, but we're not at that point in trial where I can give you those facts yet.
And you said that facts in the story have to resonate with the jurors' pre-existing attitudes and beliefs because everything gets filtered through that. How do we figure out what the key attitudes and beliefs that they have in the limited amount of time for voir dire, and then how do we figure out how to use that?
It depends sort of on the value of the case. That's where focus groups and mock trials come in really handy, of course, because you can find out what beliefs jurors are generally filtering the facts through. Some things, are decently obvious in specific cases in terms of, jurors hate insurance companies in general. Jurors like doctors and trust them. There's beliefs that are not across the board. There are some jurors who don't like doctors, and so you can ask about those, and that those are going to come up. And sometimes it takes a trained eye to see what those issues are going to be in the case. But oftentimes you can sort of look at it and even talk to people if you can't do a normal focus group. Go talk to some neighbors and find out where they seem to get hung up on it. And then you have to craft questions for voir dire that deal with that so you can find out where they stand. So part of it is figuring out how to tell the story, and part of it is figuring out what the story even is. For things like a med mal case, they like to focus on the bad health of your client. And so you obviously have to deal with any pre-existing conditions and things like that. But when do you bring that up? If you do it early, then that's what jurors focus on, and all the other facts get filtered through. Well, she was already in bad shape.
Yeah.
Whereas if you focus on, doctors are here to help people. There's no sign on the door that says, if you are overweight and a smoker, we can't treat you. They're there often for people who are having trouble with something or have a lot of pre-existing conditions and then have compounding issues, causing more issues. That's why we have doctors. If everyone was in perfect health, we don't need them. So, to frame it that way first and then say, okay, so she had all these other things and here's why that doesn't matter. Let me put those things into context for you. Same with like a police misconduct case, right? They like to blame the criminal for, the police had to do what they did because there was a criminal here and they're a bad person. Yes, but there are protocols in place because police act within normal society. If they are shooting at somebody through a car, there are pedestrians on the other side of that car. Doesn't matter that there's a criminal in there. They have certain rules that they follow because there is a criminal in there. And so framing is just figuring out how to tell the most persuasive story, what facts you want to focus on, and what order you need to tell them in.
One other thing that when we talked before to prepare for it is something that's one of my pet peeves, and that we'll be in litigation, for 2-3 years sometimes, and the defense has come up with all these ridiculous, offensive to us defenses and theories, and then the lawyers that I've worked with, especially some of our co-counsel, they want to make the case about how bad the defendant is for coming up with these things and how their defenses are all wrong. And I've always thought, no, we need to play in our field, not their field. And I noticed you said, we should focus on why our version of the facts are true, not playing the defendant's game. Why is that? And can you tell us a little more about that?
So, I think if it's outrageous and the jurors get to know a lot of the background information about how the defense has been stringing you along or lying about things, then I do think you can focus on it because then you're focusing on their lies, which means that anything they present is not trustworthy. So I think that's a different category. But in general, when they want to throw everything up against the wall to see what sticks. And so you can't spend your whole time batting down every single one of those things that comes at you. Then your whole case becomes defensive. And so I think you have to focus on, the actual facts of your case. So if you have, a insurance bad faith case, for example, often they want to focus on what happened in the accident and who got hurt and why they got hurt and why the insurance got involved. But none of that is relevant. At the point that the insurance got involved, let's focus on whether they followed their policies and their procedures and whether they put the interests of their client above their own. Like that's where we need to focus. And so we can talk about what happened in the wreck and we need to talk about that, but let's not focus on that. And every time they bring it up, it's just a red herring. they're putting things out of context. And so let's always bring things back into context. And this is what we're focused on. So you can't play a defensive game all the time. You need to focus on your best facts, focus on where you need the jurors to be. Don't ignore what they're saying, but keep reminding the jurors that, okay, let's address that point. And let's also remind you that it's irrelevant. They're playing games with you. I had a lot of people coming to me wanting help, and they would say, I ran some focus groups, and can you help me with this? Because, a lot of people don't have the budget to hire a consultant to do that part of it. And so they're trying to all do it themselves, which is wonderful. I think, the more the attorneys do their own focus groups, the better. But you have to do it in the right way. Otherwise, it ends up being misleading for you. And so when I look at how they've been doing it, or how the jurors were recruited, or how they presented the evidence, then I have to say, we can't really rely on this, because it could be useful, but I don't know. It could be something that is going to throw us way off track. And so I can't rely on that research. So I'm trying to get, people to, at least if they're going to do their own research, to do it in a way that's not going to compromise the validity of the results. So, I wrote this ebook. It's a quick read, and it's sort of a reference guide for, how to recruit, how to choose the type of focus group you want, how to write the scripts, things to watch out for, to set yourself up for success.